Hello and welcome to Infocus. I am G. Sampath. A new controversy seems to have divided the art scene in India. Many of you may have heard of the poem Sab Yaad Rakha Jayega. It became a kind of an anthem of sorts for the anti-CAA protests in 2020, in February 2020. It is a protest poem, and one of the famous English rock musicians, the Pink Floyd co-founder Roger Waters, recited it in London at a protest event, and it became a global phenomenon. Now, the poet who wrote this poem, Aamir Aziz, has claimed that an artist known as Anita Dube, who is also a well-known artist in her own right, she has quote-unquote stolen this poem or lines from this poem and used them in her artwork for profit without giving Aziz any kind of compensation or credit or even seeking his consent. Now, for her part, Anita Dube has said that there was maybe an ethical lapse and she has offered some kind of remuneration, compensation to him. But it's clear that Aamir is not impressed with whatever she may have offered, and he has sent a legal notice to her. So now the issue has reached the legal domain. And this has also been in the social media because Aamir Aziz has shared his angst about this entire episode with social media posts, and Anita has claimed that there has been a social media trial of sorts, and there has been a lot of back and forth in the social media, in the media as well. Opinion pieces have been written on the whys and wherefores, rights and wrongs of this entire episode. Now, where does the entire question of intellectual property come into the art scene? Because some artists also believe that they have a right to draw on what they call the cultural commons. You know, if you want to quote or cite or parody certain works which already exist, you have the right to do so. There must be some exemptions for those kinds of artwork, especially progressive, revolutionary art, etc., etc. So this is the subject that we are here to discuss, and joining us today is Shantanu Sood, who is a lawyer specializing in intellectual property related issues. Shantanu, welcome to the pod.
Thank you, Sampath, and it's a pleasure to be here.
Just wanted to say that this entire podcast series is quite a revelation for me, and I think it's a really important podcast that you're doing that brings out the information, that crystallizes the issues and distills them in simple terms for the public at large. So it's a good feeling to be on this.
Thank you, Shantanu. Thank you for your words of appreciation. So to start with, I just wanted to have your initial thoughts on this whole episode involving this poet activist who's famous for this protest poem and is also a brilliant writer, and Anita Dube, who is a well-known artist and curator with a large body of work behind her. So are such incidents of theft, as Aziz puts it, and ethical lapse, as Dube has put it, are they quite common in your experience, having been a lawyer of intellectual property disputes for such a long time? What is your initial impression of this?
I think it's quite a common occurrence, and it does occur across the board for different types of works, for different types of mediums. More, I would say, in the context of in the commercial field, where works of art or works of literary or dramatic or musical works have been created for commercial purposes, and in those scenarios you find that there's a lot more borrowing or so to say ethical lapse. But this controversy, I mean, unfortunate as it is, I think it's important to then now just distill it into the legal issues that are at play here. And there are three basic elements that this controversy revolves around. The first is, does Aamir Aziz's work, the poem in question, is it a copyrighted work? And for that, we need to just understand that copyright is basically an expression of an original expression that in a tangible form, and it must therefore either be a literary work or an artistic work or a dramatic work, or a musical work. I mean, these are the categories of copyright that the law broadly recognizes. Is it an original work? And I think from what I've read, and I'm just going to start distilling the undisputed facts out of this controversy, that it is, in fact, yes, an original work. It is his poems, and therefore it is protected as a literary work. Copyright subsists. Now, what does that mean under the law? What does having a copyright mean? The copyright gives you an exclusive right, the owner or the author, in this case, they're one and the same, the exclusive right to do or not to do certain things. And broadly, these rights are the right to reproduce the work, the right to adapt the work, and the right to communicate the work to the public. And assuming and concluding, for the purposes of this discussion, that there is in fact a copyright in the poem, then Aamir Aziz has that exclusive right to do so or not do so. And the corollary to that is that he also has the exclusive right to authorize others to do so or not do so. And then the final outcome is, and the third element, does Anita Dube's artistic creation violate his exclusive right? And in that sense, if you look at the fact that the exclusive right is to reproduce, adapt, and communicate to the public, and these are mutually exclusive, they are not one in sequentially connected. She has adapted his work. She's taken a full stanza, from what I understand, of his poem. She's adapted it into a new artistic expression, and she's communicated it to the public. And from what I do understand, it has been without his consent. Therefore, from a very initial understanding of this entire controversy, it does appear that she's violated his right. So that in itself now, like, I would want to mention that there are cases, and each case turns on its own facts. But broadly, having identified the copyright, having identified the rights that flow out of that copyright, and the prima facie violation of that copyright through this adaptation and communication, it would be justifiable to conclude that there does appear to be a case in favor of Aamir Aziz.
Right. Now, in response to the allegations which Aamir has made about Anita Dube using his work without following the due process, etc., Dube has said that she has also used quotes from the works of Martin Luther King and bell hooks, and she didn't feel the need to take their permission because they are in the public domain, etc. So is that like a legally valid defense, or is there a distinction to be made when you said copyright would apply to original work in tangible form? So does it apply to quotes as well? What if she were to argue that, okay, when I may say something, but it's a quote and people can quote me, right? So she has quoted Martin Luther King, she has quoted bell hooks, and she has quoted Aamir Aziz. So, like, how would you respond to that kind of a defense of whoever is making that kind of an argument?
It's a very interesting question, and also quite a tough question to answer from a very simplistic perspective. But what I would like to just emphasize on is the fact that a quote, there is no distinction between a quote per se and a poem when it comes to the categorization as a literary work. There are certain rules that apply, but let me just say that if a quote is within the realm of a literary work, and it is categorized as a literary work that is entitled to copyright protection, then the use of that quote without permission would be a violation of the owner or author's rights in that quote.
What if that quote was a tweet? I put out a tweet.
Well, I mean, a tweet is a tweet.
It's not a literary work, man, just to...
So the literary work doesn't really... I don't know. I don't think you need to define literary work in the sense of a novel or a work of lengthy content. I think the quality of a work determines its literary nature. And a tweet, whether it's a 2-line tweet or even a 5-word tweet, could possibly qualify as a copyright, as a literary work that is entitled to protection as copyright. And I'm glad that you mentioned the word tweet, because it's expressed in a tangible form. The minute I put down a tweet, it is expressed in a tangible form, and as long as it's original, it is entitled to copyright protection, provided, of course, the law recognizes that the length of that tweet to be within the realm of literary work. So there are exceptions. There can be, I mean, for instance, there could be a very simplistic distillation where I could say that, a 3-word sentence may not qualify for copyright. But I think in these cases, it's the quality of that creative or the original expression that matters more than the length or the quantity of that original expression. So it's important to keep that distinction in mind. And coming back to your question then, if, for instance, Nelson Mandela's or Martin Luther's quotes or bell hooks quotes are within the realm of copyright of a literary work that's protectable, then her use is possibly a violation of their owner's rights.
Okay. So that defense won't really then wash, I guess. Now, from what I understand as a layperson, legally speaking, there are three themes which keep coming up, both in what Aamir Aziz has said and also in other kinds of opinions that have been expressed. One is consent before reproduction. Second is giving credit, and third is compensation. So none of the three things have happened in this episode, and most people, I think, would assume that when you give credit, then it is fine to do whatever you want, so long as you are not doing something commercial, you're not trying to profit from it. So is that correct? I mean, if say Anita Dube or whoever said, okay, I'm giving credit to this person, then I don't have to then go and if I'm not trying to make money from it, then I don't have to worry about any issues. Is that okay or?
No. The short answer to that is no. But there are exceptions, which I will elaborate on in a bit. The thing is, as long as there is an exclusive right? And the word you used was consent. Consent is required to do any act that falls within the realm of that exclusive right? And under the Indian law, I mean, look, copyright is a recognition of a right. It's a statutory right. And the statute defines the boundaries within which this right operates. So we have to understand that the statute says that if you want to do something, you need to seek that person's consent. And the word the statute uses is a license. And it has to be a written license. It cannot be an oral license because the statute now defines it as a written license. So you do have to seek that person's consent before you're able to take that person's work. Because that person, the owner, the author.
Even if I'm not doing it for profit, I'm not going to use it for any artwork I'm going to sell. I'm just going to use it in my artwork and put it on display. Right. Even that is not okay.
That's not okay unless it falls within the exceptions again defined by the statute. And I will elaborate on that in a bit. So the question here really is, the author and the owner have the right to control how the work is used. And in order for them to control how the work is used, their consent is required before that work is put to use by a third person. Right? I mean, it's as simple as that. Now, coming back to the question of giving credit, copyright, there are certain kinds of exceptions to the copyright that an author enjoys, and certain acts fall within those exceptions. And broadly, I mean, for the purpose of this controversy, it would be something that's created for private or personal use. The second part, which is the important part, is it's created for review or criticism or commentary of a work or any other work. And the third is news reporting. Now, the law also then says if your work falls within the exception of review, commentary, which includes criticism, you must credit the original art. And that's where I think this prevailing feeling that if I'm doing something non-commercial, but I give credit to that person comes from. Possibly also from the third exception, which is news reporting. For instance, as a reporter yourself, you are entitled to report or review or critique a certain work, and you would obviously reference that work. So, I mean, I think the ethical norms in news reporting entail giving credit, or at least identifying the work or the author of the work if you have knowledge of that while you're reporting. And I think, so all of these prevailing feelings that credit itself is sufficient to overcome a dispute because it's non-commercial come from these exceptions, but not all forms of expression fall within these exceptions.
Right. Now, Anita Dube has responded to this intervention from Aziz by saying, okay, I'm not going to be, I'm withdrawing whatever artifacts are there in my solo exhibition at Vadera Art Gallery. I'm going to withdraw them from sale. I'm not going to make any money from those artifacts which use your poem or lines from those poems. But Aziz had also wanted her to withdraw them completely, not even have them on display, but which I believe they have refused to do. So is that a problem as well, or what does the law say in such a situation? Can she not display them as well? If she says it is not for sale, even then it's not okay to...
Right. I mean, yes, it's not okay. You have to understand, I mean, again, I'm only delving on this issue from what I've read and what's been out in the media, because I do not know the full facts. But assuming for a minute that the facts exist as the media has reported it, which are that she created these works, she displayed them in a commercial gallery for sale, was then, and Aamir Aziz then sent his objection to the display and the commercial venture surrounding that display. And then as an afterthought, the artist in question has said, okay, I won't sell them. That does not make the actual display okay, because it is still an infringement. The Copyright Act and the law surrounding copyright does not distinguish between commercial and non-commercial. An infringement is an infringement if it does not fall within the exceptions of fair dealing that are defined. So whether then it's commercial or non-commercial is immaterial to the act of infringement. And the continued display would then amount, in my view, to a continued infringement of his rights. Now, the other aspect that I think has been slightly overlooked is the gallery's possible liability. Now, the gallery in the first place, so the infringement is not simply limited to the person who's created the infringing work. It also includes people who further the communication of the work to the public. So the gallery clearly falls within that space. And now that the gallery knows that the work is infringing or has reasonable grounds to believe that the work is infringing, primarily because Aamir Aziz has, I think, written to them as well separately, the continued act of display potentially now exposes the gallery to civil and criminal liabilities. And that must also then be taken into account. It's not sufficient for the gallery or the artist to say that these works are no longer for sale. They're still being displayed. And the third, and I think a crucial element of all of this, is that the copyright law also recognizes an artist's or an author's moral rights, which include the right to prevent the mutilation of his or her work. And that affects the honor and reputation of the author in question. Now, Aamir Aziz, I think, has gone on record to say that, look, if you put my poem on a placard and you stand in a protest, I'm with you. That's the honor and reputation that he's signifying that rests with the work.
It goes with the theme of the poem, which is it's a
correct
poem.
But it also, I mean, he's made his feelings clear that this work is a revolutionary work, and therefore he's also made his feelings clear, as far as I understand, that taking parts of that work and putting them in a private commercial space, in an artwork that is for sale and for private use, harms the nature of the work, harms the reputation that is associated, personally harms him. And therefore, I think it also then, we must consider that it affects his moral rights. So those are the three prevailing aspects that I think the people who are continuing to display, if they are indeed continuing to display, must take into account and must keep in mind, because potentially their liabilities then magnify as well.
Right. I mean, I really appreciate how beautifully I've explained the legal dynamics of two of these three aspects that I sort of brought up. One is credit, which I've explained, consent which you have explained. The third aspect I think is a little bit more tricky perhaps. I'm curious to know how you would sort of navigate that, because compensation, I mean, if someone has been using, suppose I made some poem or a work of art, has been using my work for a long time, and they have not just made money from it, but also they've got social capital, cultural capital from it. I mean, as an artist, they've used my work to generate that as well, and I come to know of it just 3 months ago. Okay, now what kind of compensation would be legally due to me from this? Not just from sale, there's also other kinds of benefit which have accrued to whoever has been using this. This is one part of my question. The second part of the question is to do with what you just said earlier, that this Sab Yaad Rakha Jayega, this poem was created in a particular context of protest, and the poet has said, I don't have any issue with it being held in a placard at a protest or a hartal or campaign kind of a thing. But to transplant this into a commercial space or even a private space, which is not a space of protest but which is just for display, that probably sort of violates his moral right or whatever. Now, on the one hand, one could argue that it is not meant for a commercial space, but at the same time, we are also saying, since you are using it in a commercial space, compensate me for it. So, is there a contradiction here?
It is possible to consider them as contradictory, but in my view, I don't think that's a correct way of looking at things. Compensation, in fact, defined under the law. So, I'd like to just inform on what remedies are available, and apart from I'm not getting into whether they're civil or criminal, but just broadly, if this were to go to court and a court did find that there was an infringement of Aamir Aziz's right, he would be entitled to injunctive relief, damages, or accounts for profits. Now, these remedies are available to him, and it is up to him to choose which ones he wants to claim, one, all, or none, right? I mean, and none being that he wouldn't go to court. So, copyright is a private right. It is enforceable only if the author, the owner, chooses to enforce it. And therefore, the remedies that the relief, as we call them in court, that they ask for is what the court then finally adjudicates on. Now, compensation, in this case, would compensate him for the injury caused by this unauthorized use. And it's easy for us to sort of look at it in terms of saying that, or somebody is just after the financial benefit through infringement. But you don't want to distill everything down to such a base or a crude element. I don't think the idea of damages, the idea of compensation is to give you money for a wrong that's been caused to you. I think that the money is the only medium by which a court or society is able to redress the hurt that's been caused to you. And I think that's an important distinction here. Aamir Aziz has not, as far as I know, used this poem in a commercial sense. He's not written the poem for a commercial purpose. So to say that the compensation would only just be a commercial transaction in nature would not be the very correct way of looking at it, and definitely not the correct way of looking at the idea of damages as the law enshrines it for both for copyright violations or for any other remedy. It's simply a means by which the court tries to give you just compensation, or to remedy the wrong that has been caused to you. And the best way and the only way I think the court can do that is to assess it monetarily, right? So the philosophy behind damages has to be understood before we try and just categorize them as financial gain or a financial loss.
So it's not just about sharing whatever benefits the person may have accrued, it's also about offering some kind of redress which finds expression in monetary
medium. That's precisely how it should be seen. But of course, then it's up to Aamir Aziz as well to decide what he wants out of this. And the law entitles him to that simply because the law allows him the creative control or the absolute control over the copyright that exists in this work, so that it then entitles him to what remedies he seeks out of this violation.
Right. Now, just moving slightly into some kind of a grey area vis-a-vis the legal terrain that we have sort of covered so far. Many artists would want to invoke the concept of the cultural commons, or just the commons, when it comes to the production and circulation of art and artworks that use citations, that use quotes, especially in the context of radical art. And I don't know to what extent, I'm not an art historian or an art critic, so I don't know to what extent Anita Dube's case would fall into that category, but let's assume that it does. So is that, how does that fit in with this entire legal, the very clear black and white legal scenario? What about the kind of loose freedoms which an artist might feel that he or she enjoys? And in that sense, would it possibly be misplaced to hark back to the notion of intellectual property and private ownership, when a poem is not just the outcome of one person's creativity, but it's also the outcome of a particular historical and cultural moment, which, like the anti-CAA protest was. Well, that's an argument some artists would like to make as well. Like, what are your thoughts there?
I'm glad you said that you're not an art historian. Neither am I. So I'm not going to approach this from the context of a larger cultural debate, because I think such debates are important, and I think they help push the law and evolve, and let the law evolve in a way that society deems fit. But I do take exception to this notion that the cultural commons implies that every outcome of that out of that commons is shared resource or is public resource. I mean, if we were to go down that road, and I could be very wrong, but from my simplistic perspective, if we were to go down that road, all art would then be cultural commons. Where would an artist, how would an artist survive? The whole point of copyright, the point of intellectual property, is to advance society, advance the collective wisdom of society, so to speak, through individual endeavors. And in recognition of that individual endeavor, there is reward being given by saying that, look, we'll give you some monopoly over your individual endeavor, so you're able to feed yourself, fill your stomach, and revitalize yourself to further create new endeavors, or to keep on this journey. Otherwise, why would an artist be able to produce masterpieces that now are really the enriching part of human society, if doing so would entail no reward, right?
I guess that would be possible only when it's under a system of patronage, where there is a king who patronizes.
Again, but even the patronage then is seen as a reward, right? Because people then understand that there is somebody out there looking out for him. So, yes, I do understand that this poem has been born in a cultural setting, but the expression of that poem, or the creation of that poem is not culturally shared, because it's not being created culturally. It's being created individually. It's his individual expression, and I think it's important to understand that the individual expression is what the quality of that expression makes the poem famous. But the individual expression is what the law protects, for the simple reason that it entitles him to get some benefit, whatever benefit he chooses. It doesn't have to be monetary. It can be a social benefit, like you said. But it is some benefit that he gets out of it. And we have to see all endeavor in that form, right? That is the human society we live in. So I wouldn't really consider cultural commons to be a contradictory element of intellectual, or contradictory to intellectual property or private ownership. But I do not also want to I do not want to restrict intellectual property as just another fancy word for private ownership. I don't think it is that. It's much more than that. You have a global movement, for eons, that have been born out of individual endeavor, and intellectual property just recognizes the the effort, and it rewards the effort put into that individual endeavor. So the purpose of intellectual property is a little bit more diverse than simply a sort of a monopolization or a private ownership concept.
Now, there is also this concept of copy left, which has also been invoked by Anita Dube in a response to Aamir's allegations. Now, is copy left, is it just an ethical or a creative imperative for artists and progressive writers and so on, or is it also enshrined in copyright law in some form? How does it work?
So like I said in the beginning of this discussion, copyright gives you the right to do or not to do certain things. Along with that comes the right to choose what you want to do with your work. So copy left and the Creative Commons, and there's a huge movement now which talks, and I think that's where the cultural debate is, that we're talking about how to evolve the notion of copyright and how to involve collaboration without being ensnared in the concept of licenses and so on and so forth. And the copyleft movement and the Creative Commons, I'd like to use the word Creative Commons because it's slightly broader than copyleft. Copyleft really started with software licensing. So the Creative Commons, I think, would be a more apt term here. It derived out of copyright, and essentially it's a free license. So it is a license. The owner of that copyright is consenting to the use of his or her work by the public without any compensation. So he's the owner saying, this is my work, I own the copyright, and I hereby license it to the public at large on these terms. And most of the terms are that any other derivative work that comes out of it must also then be free for public use. But you see, the underlying element here is that the control and the decision is with the owner or author, right? And the Copyright Act also, the Indian Copyright Act, apart from the fact that you can have these free licenses, which is what Creative Commons is, the Copyright Act also allows for the author to relinquish his copyright. So if an author feels that this work belongs to the world, he can generally relinquish the copyright, and therefore after that it's free, it's in the public domain and free to use.
But if an author relinquishes his copyright and then it's in the public domain and somebody else draws on it and then uses it for commercial purpose and makes money from it, then is it okay for him to have a problem with that? Like you said, usually they make it derivative work should be also free from copyright.
I think if you relinquish your copyright, you would still maintain a moral right. Again, a very tough question you've posed because there is no straight answer. But I think, no, once a work is in the public domain, if you were just to stick to the idea of public domain, then it's free to the public to do what they want with it. And Mickey Mouse, I think, is a great question. Has just, I think, in the preceding year or the year before, has finally entered public domain. And the first things that happen are that these cartoon horror stories come out with me featuring Mickey Mouse, and you can't do anything about it because it is in the public domain. So, in short, yes, if a work is in the public domain, it's free for the public to draw on and use and create new works out of that.
But if the artist has put a conditionality, this is Creative Commons, but only if the work you produce from it is...
So that wouldn't be a relinquishment. That would be a free to use license, which means that the copyright still exists, but these are the conditions under which I allow you to use it without paying me any royalty or license fee. That's what it means. And those conditions then determine the further use of any derivative work that comes out of this original work.
And if the derivative work is for profit, then that person can be taken to court.
Yes, that person would be taken to court because it's a violation of the terms of license then.
Right. Fascinating to sort of think about this. One last question, Shantanu, before we wrap up. Many people have found issue with the way this entire controversy has been debated, also because they seem to think there is a distinction between the first worldish kind of enforcement of intellectual property rights and copyrights and how it is generally sort of assumed to be done in the global south in India, where there's a lot of piracy happening. You have photocopies of important texts being distributed officially in university classrooms. Piracy, the threshold of tolerance is perhaps a little higher compared to the first world. So, as someone who has practiced in the global north, you practiced in Washington DC, New York, and you're practicing the same kind of disputes or sort of tackling them in India. Do you agree that there is perhaps a difference in cultural milieu, legal milieu between the kind of standards of enforcement in the first world and how it is in India, and also differences in our awareness as well, which might be lesser here compared to the first world, and therefore the law which is applicable here maybe also needs to be used, maybe applied a little bit differently. Do you buy that argument?
Again, it's there are multiple layers to this argument, and one of the layers is whether we need to have a copyright regime that mirrors the West. I think that's a cultural argument that we don't really need to get into at the moment. I do, however, want to point out that I don't think the idea of copyright is a Western creation. If again, I'm not a historian and I'm not an art historian, but I do understand that I do believe that if we were to look into the Indian context and the cultural history of the subcontinent, the idea, what you mentioned about patronage, about all of that, were in some ways a recognition of some form of copyright. It wasn't called copyright, wasn't treated as a legal right.
Recognition of authorship.
But authorship, yes. All of these things were an early form of copyright, and I think societies around the world have advanced along these early notions of recognitions and then further been crystallized. Having said that, the second part is, I think we need to also understand that copyright now is actually a globally uniform law. There is something called the Berne Convention, which again, you could argue is a Western creation, but it's an 1886, if I'm not wrong, convention, which India is a signatory to. And this convention now provides some minimum standards that all member countries must adhere to. And the minimum standards are therefore uniform across the world. The Indian Copyright Act is now compliant, has always been compliant with the Berne Convention, and is probably as analogous to the UK laws, to the US laws, or to any other country's copyright laws that are also members of the Berne Convention. So, imposition aside, if we were to look at the treatment of copyright across the world, we would have to say that there are about 180 or 90 countries that are legally obligated to have minimum standards of copyright. So, it's a uniform law. Coming to the third part of your question, whether there's more recognition in the West and less recognition in the global South, I think it all comes down to enforcement and the ability to enforce, right? I won't say that there's greater recognition or greater respect for copyright in the West. I think the global North also violates copyright. In fact, I've actually worked on a lot of cases involving fashion, where the global North designers have come to India and they've ripped off Indian designers, taken them back and launched collections. And with the hope that again, I'm not getting into whether they've done it deliberately or it just sort of moved up some cracks or, sort of went unnoticed. But the fact is that they've been caught and they've had to pay. In India, the tolerance is simply a question of enforceability, whether the person who's...
In India, we see there are so many examples of, music composers in Bollywood sort of just taking tunes from here and there.
Right. Because I think it worked both ways. I think there was a little bit of a sense that you could adapt, there could be borrowing. But at the same time, I don't think that's because we are culturally different from the rest of the world. I think it's just because people were perhaps aware that enforcement of those rights would not occur in India. And traditionally, courts would not really give damages. There would be lower quantum of damages, for instance. There would be token damages. So, you could really get away with a slap on the wrist in terms of injunctions, but not really be made to pay monetarily. In the US especially, when copyrights are violated and courts do find that the infringement occurs, damages run into millions and millions of dollars. I don't know if you're aware of the Pharrell Williams case. He was guilty. He was found guilty of infringing Marvin Gaye's tunes, and ended up paying some millions of dollars and plus, I think, a share of profits. So there are many other cases like that. So the quantum of damages determine, I think, what you mean by tolerance. Now Indian courts have really caught up. We are now fairly advanced in the way we calculate damages, the way we award damages, and the way we view violations of copyright, right? So we are seeing more and more cases now come up into Indian courts that are being adjudicated on, very interesting cases that are defining the boundaries of copyright, defining the boundaries within which exceptions to copyright work, and also finding liability where monetary damages are being awarded. So as soon as this cultural shift has occurred in our Indian courts, we're seeing more enforcement and less tolerance of piracy. So I think really, ultimately, it's all a question of what does a person get for enforcing his copyright through the legal system.
Right. So broadly, there is a convergence of the legal regulatory regimes governing copyright across the board, global south and the north.
Completely. At least in India, it is. And we are also becoming a society where we are able to now fight for these rights. The copyright amendments that came in 2012, what we call the Javed Akhtar amendments, were very significant because they were literally a reclamation of the lyricists, the authors, the composers and the authors, the lyricists. Reclamation of their rights over their creations, because, otherwise producers were able to take those rights and use them without compensation flowing back to the lyricist. So those sort of amendments have made it possible, and I think Indian copyright law has evolved. It's continuing to evolve, but it's also being very strict in its application of the law.
It's a very fascinating topic, and we'll, as you said, and people have to fight for their copyright rights, as Aamir Aziz is trying to do, and we'll wait and watch how this entire episode unfolds. Thank you so much, Shantanu, for coming over, joining us in this conversation. It was an absolute pleasure talking to you. Thank you.
Oh, thank you, Sampath. It's been a pleasure here.